much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal. Today, we are going to talk about the EB-5 program, both regional centers and direct investment EB-5. And before we get started, just a few housekeeping items. First and foremost, if you do have questions during the presentation, please feel free to add them to the chat box or the question and answer box. We will get to all questions throughout the presentation. In terms of, as we go through the presentation, or when we're done going through the presentation, we will send you a number of things. We'll send you a copy of the PowerPoint presentation that you'll see on the screen. We'll also send you an EB-5 guide. The guide talks about a lot of the things that we're going to go through in this presentation. And we'll also send you a link to where you can set up a consultation if you need additional information, and also a link where you can see the actual video. This video is going to be recorded, and what we do is we post these on YouTube after we have done the webinar. We do encourage you to subscribe to our YouTube channel. You can subscribe to the channel and click on the notification button. We regularly post videos 3 or 4 a week, and on EB-5 topics and a number of other immigration topics. And yes, so without further ado, let us move into the presentation. So before we jump into the EB-5 program, I just want to briefly touch on the different types of investor visas in the United States. And keep in mind, for each of these visas, we do have separate webinars. So if you go to our website and you go to the events page, there are webinars scheduled through October, and we do have regular webinars on all of these topics. So the first investor visa is an E2 visa. The E2 visa does require that you be a national of a treaty country, but it has a much lower investment amount than the EB-5 visa. So something to consider. In terms of job creation, the E2 visa doesn't have a set number of jobs that have to be created, as you'll see what the EB-5 does. But definitely the E2 visa is a visa that is very, very popular investor visa, available to nationals from around 80 countries in the world. So something definitely to look at. The other visa that we see, investor visa that we see, and this is actually a green card, it's called a national interest waiver under the EB-2 category. And this is based, the requirements for this are based on a case. The case is called Danisar, and it really has 3 different requirements. The first requirement is that your endeavor has to be in the national interest. The second is that you have to be well positioned to advance the endeavor. And then there's a balancing test that looks at why the government should waive your labor certification. But again, there are a number of different webinars we have on national interest waiver. They're complete separate webinars that take an hour to go through all of the requirements. Definitely either sign up for one of those webinars in the future or go to our YouTube channel and see some of the webinars that have occurred in the past. The other investor visa, which is not very popular at all, and again, there's another webinar on this, is the International Entrepreneur Rule. That is really if someone is ineligible for an E2 visa because they are not a national from a treaty country. They could perhaps look at this if they have investment from certain types of investors or grants or other mechanisms that show that there's the endeavor has substantial economic promise or merit. And then finally, the EB-5 green card, and we're going to spend a lot of time today going through that. So, one of the things I wanted to touch on before we talked about the actual requirements are, this program has gone through a number of different changes over the last year and a bit. So what happened with this program was that a few different things happened. So at the end of June in 2021, the regional center program expired. The regional center part of the EB-5 program is the part that has to be reauthorized by Congress every few years. And for the first time, it's kind of an unprecedented event that it lapsed for such a long period of time, because it lapsed from June 30th to March 11th of 2022. The program lapsed, so that meant that applications that were in the pipeline couldn't be adjudicated, and you couldn't submit any new applications. So really, really impacted the regional center program. And then the other thing that happened is that during the last administration, they increased the investment amount on the lower end from 500 to 900,000, but then a number of people sued. They won the lawsuit, and the district court said that the $900,000 amount was not legal, so it went down to 500,000. So that $500,000 amount was available for direct investment EB-5s from the end of June up until March 11th, and then on March 11th, they revamped the rules. And what they did is they came up with the new investment amounts that we're going to talk about during this presentation, and also clarified a number of different aspects related to how people who invested during that several month period after June 30th, how their applications would be treated, et cetera. So really clarified a lot of things, a lot of different things in the program. But good that all of those changes were made, and I think important for the program, because it was really disappointing that it was in flux for so long. At least the regional center side was in flux for so long. So now let's jump into regional centers versus direct investment. So both of them are EB-5. And really, I think that when you're looking at a regional center, you're looking at a different investor profile than when you're looking at direct investment. And even though they're in reverse order on the slide, but direct investment really is an individual who is an entrepreneur and wants control over their business and wants to start their own business or invest money in an existing business and really have the control and ability to drive that particular business forward. This person's concerned with the green card, but also concerned with profits and kind of the ability to control their own destiny. In contrast, the regional center program, that would be something like, for example, let's say that a particular enterprise like a hotel was being built, and that hotel wanted to raise money. They would set up a structure where they would take on a number of different limited partners who don't really have any say or ability to control the particular outcome. And they would take, the investment amount, let's say in this case, $800,000 from each person. And they would really be passive investors. They would get a very, very small return, usually fraction of a percent. And really would be, at the end of the day, it would be negative return, because usually for regional centers, there are administrative fees that you have to pay. And when you take into account those administrative fees, the return is actually negative. So the investor profile for a regional center is someone who really is just interested in the green card and doesn't want to have to worry about the day-to-day operations. And just so in terms of statistics, over 90% of the applications for EB-5 are regional centers. So although the direct investment is an excellent way to get a green card, in particular if you're on an E2 visa or if you just want to start a business, it's an excellent way to get a green card. But the overwhelming majority of the EB-5 cases that are filed are actually regional center cases. So now let's get into the crux of the EB-5 requirements. So what one great thing about the EB-5 program is that the requirements are very objective. So, you're not kind of wondering, when you look at E2, you say we have to invest money, it's a substantial amount, but they don't tell you how much. You have to hire employees, but they don't tell you how many. But EB-5 is different. They're very specific with respect to what the investment amounts have to be and what the employee hiring has to be. So for this particular green card, you have to invest either 800,000 or 1,050,000 in what's called a new commercial enterprise. So that's not a new business. It doesn't have to be a new business. This doesn't have to be a new startup or investing in a new existing business that was just recently created. A new commercial enterprise is defined in the statute, and its business is created after 1990. So the business could have been around for quite some time, and if you invested in that particular business, you could be eligible for EB-5. The difference between the 800,000 and the 1,050,000 is really has to do with where the business is located. So if the business is located in what's called a targeted employment area, so that's either an area that is where the unemployment rate is 1.5 times the national average. The unemployment rate right now, I believe, is 3.5%. So 1.5 times that number. If you were starting the business in an area like that, you would qualify for the 800,000. And this applies to both regional center and for direct investment. Or you would invest the 1,050,000. The other way you can qualify for the 800,000 is if the business is in what's called a rural area. So that's defined by local government. It's an area that has it's going to have much lower population as opposed to an urban center, which is a city. So then the other thing to kind of keep in mind is when you're investing money, whether it's in a regional center or you're starting your own business or investing in another existing business, is that the certain things that you spend money on can or cannot be included. So if this really applies more to the direct investment, if you are starting your own business and investing in a number of different things like legal fees don't count. Things like, fees paid to administration fees don't count. So even when you're going to a regional center, for example, their administration fee could be $50,000, but then that would mean you would have to invest $850,000 rather than $800,000. And then on top of that, the legal fees that you paid for that, aren't part of the investment. So you have to pay the $800,000, the administrative fees, and then the legal fees. And then keep in mind that for the other thing to keep in mind is with the EB-5 program, that all of the money that you invest, you're required to show where that money came from and that it came from a legitimate source. So this sounds like it's an easy requirement where you can just say, I saved the money over time, or I sold a house, or I inherited money, or whatever the reason. But the actual requirement and the documentation that is required is quite extensive. And keep in mind now, this is one of the March 11th changes, is that you not only have to prove where the $800,000 came from, you also have to prove where the administrative fee and or legal fees came from. And that's changed, because before you didn't have to do that, but that could significantly, sometimes the administration and legal fees could be $75,000 or more, and you'd have to show exactly where that money came from as well. And as I said, the exercise with respect to source of funds, it's not for the faint of heart, because it is quite an extensive exercise, and they're not really interested. The government's not really interested in explanations. They want documentation. The one other thing to consider with the investment is that it can be made over time. So we just had a recent approval for someone who had invested. It was when the investment amount was $500,000. Someone had invested $500,000 over several years. They were on an E2 and they continued to invest money over several years, and they were, granted their EB-5 petition was approved. But the only thing to keep in mind is that every time you invest money, if you do want to qualify for the TEA area, the particular jurisdiction or the particular location of the business has to be in a TEA every time you make an investment. So that's something to keep in mind, or it means that you have to jump up to the $1,050,000 mark. The other thing to keep in mind is sometimes people will have, an E2 business, or, they're running the business, and let's say they have an E2 business and the business is making $2 million, made $2 million in a particular year in terms of net income. And then the money just sat in the company, went into retained earnings, and then they reinvested that money from the company the next year. And a lot of the time people will do that and they say, okay, well, I've invested the $1,050,000 because I used retained earnings. And unfortunately, that doesn't work for EB-5. The investment has to come from your personal funds. So you would have to either pay that money to yourself, pay taxes on it, and then reinvest it, or get other money and then reinvest it in the company and spend the money accordingly. So that's definitely something to keep in mind. And it's a question that we often get. The investment for EB-5 has to be some form of equity. So if you're doing a regional center, usually they'll give you what are called limited partnership units. If you're doing if you're owning your own business, it can be shares, it can be membership units, it can be partnership units, whatever it is. There's no set amount that you have to own. Like E2, you have to own 50%. No set amount you have to own. You can own 1%, a fraction of a percent. Nothing specific. Then the other thing the other big part of the EB-5 program is job creation. So you do have to create jobs, and you have to create 10 full-time jobs. So these jobs have to be created 2 years after your I-526 petition has been approved. And the one thing to keep in mind is sometimes the regional centers can be beneficial because they can include what are called indirect jobs. So economists will take a look at the example I gave, a hotel that's being built, and we'll be able to write a report to say, well, the hotel is being built, but the impact that hotel has on the area, like services that are going to be delivered, and the hotel is indirectly creating jobs, and often the indirect jobs that are created are quite substantial. So it allows you to more easily get to the 10. Whereas for direct investment, EB-5's indirect jobs can never count. So it has to be direct people that you hire. So 10 full-time jobs. The other thing with the jobs, that you have to be either green card holders or US citizens. And they have to be full-time jobs. They cannot be part-time jobs. There's a concept of job sharing, but for the most part, I think you should ignore it because, just better to have full-time jobs, and they have to obviously be US citizens or green card holders. And with that, they ask for proof, right? So they ask for, their passport or the I-9 documentation as the person was hired. So you do have to keep that documentation. And the other thing to keep in mind is that the money invested has to be linked to job creation. So if let's say that, for example, you invested money in a business that already had 10 full-time employees, then that money that you invested didn't have anything to do with the job creation. So you would have to create 10 additional jobs, to meet the standard. So similarly, the other thing that EB-5 doesn't permit is if you want to purchase an existing business. So let's say you purchase an existing business for $1 million, let's say for $2 million, and the business had 20 full-time employees, and you paid the $2 million to the owner of the business. That wouldn't qualify for EB-5. None of that $2 million would qualify for the investment. If you own the business, then you invested an additional $1,050,000 into the business, that would qualify. However, you'd still have to create 10 full-time jobs, because at the time you made the investment, you can't, there has to be a link between the investment that you made and the actual jobs created. So that's something to keep in mind. In terms of filing EB-5 petitions, there is, kind of a number of different petitions that are filed. One is the I-526 petition. That's the first petition, which kind of shows that you have met the above requirements that I'm talking about, that I just finished talking about. So you invested $800,000, and you're in a position to create the 10 full-time jobs, and you have provided documentation related to where the money came from. So that's that petition. So that's quite a voluminous petition. Then the I-485 petition, you have kind of two ways of getting the green card. If you're in the United States, you can file an I-485 petition, and that can be filed concurrently with the I-526 petition. That's a big change from March 11th. That was a huge change from March 11th, because given that these petitions take several years to be approved, having the I-485 petition filed at the same time sometimes gives people who are in the United States the ability to stay here on status and get work authorization while the petition is pending for 3-4 years. If the person is outside of the US, they're going to be doing consular processing. And then after the person gets the green card, 2 years after they get the green card, they file what's called an I-829 petition. And the I-829 petition is a petition that basically shows that you actually did, so this is going to be long dated, that actually shows that you did create the full-time jobs that you said that you were going to create. So some of these we talked about earlier, but I think it's worth going over some of the key changes to the program. So the program was reauthorized until 2027, which is great. So we don't have to worry about the same nonsense happening that happened before. The new filing to 60 days, I'm going to change that for the next slide, because this was made, right after the change, so that's not applicable. So people can file after, regional centers are reauthorized, they can file. Now what they did as well is they put in the law that said that as long as your petition is filed before September 30th, 2026, it will be adjudicated. So there won't be this stopping of adjudicating petitions that happened last time. Big change was the 500,000 was changed to 800,000, and the maximum investment was slightly increased, because it was $1 million before. It's increased to $1,050,000 now. And another big change was the TEA rules were changed, making it harder to qualify for a targeted employment area, because people could really take advantage of the old rules, but that's changed. And then there's some carve-outs for different visa categories that just kind of reduce the backlog for some groups that the government wanted to support. The other thing that was clarified was that applications that are filed before June 30th were going to be adjudicated, because that was in flux. We warned clients that filed right before the June 30th date that, we think that the government's going to adjudicate, but we can't guarantee that. And then we talked about the concurrent filing. And then, we talked about source of funds, that it's it really is an extreme requirement, and then the change related to administrative fees. They also provided some clarification on loans and gifts. So a gift and loan can come from anybody. The issue here had to be that the government wanted to, the issue here was that the government wanted to limit gifts to immediate family, I think parents or something like that, because what was happening is people were saying, oh, I'm giving my friend a gift. Now, if you do give a gift, then, you have to make sure that the person's paying the gift tax. And if it's a loan, you have to make sure that the person's paying back the loan, because it could be a problem, because the petition is not going to be adjudicated for many, many years. So if the government, when they come to adjudicate the petition, they see that, you gave a gift, but then you didn't pay the gift tax, that's going to be a problem. Then there was another change, which really gives some ability for people to have some remedy if something happened with the regional center, like fraud or things like that. So, a couple things to keep in mind as you're going through with both regional centers and direct investment, but the first one applies, I think, more to direct investment, where the investment has to be at risk. So you couldn't take $800,000 and put it in a bank account. It's not intent to invest. So if you put $800,000 in a bank account, you'd have to spend some of it and then have firm commitments for the rest of it, and then also not have an ability for the owner, the person who's getting the visa, to make changes to just withdraw the money. We talked about loans and gifts already. Also considerations for purchasing a business. You can certainly purchase a business, but if you give the seller the money, then you would have to invest additional money into the business, and in order for that money to qualify, you don't have to own, you can own a very, very small percentage. There can't be, in any agreement, there can't be something that says that you're, have this guarantee return or guaranteed return of your investment or interest and things like that. So even when you're doing a regional center, they can't kind of say, we are going to give you the money back in 5 years or something like that. They all do have exit strategies, and they're carefully worded. And if you're dealing with a reputable regional center, the exit strategies will be clear when they plan to give you your money back, but the documentation can't be specific. And then a lot of our clients move from E2 to EB-5, and some of the things can be included in E2, like legal fees and administrative fees, can't be included for EB-5. E2, you can purchase a business and that's no problem, whereas EB-5 you can't. The money has to be invested in the business. E2, the job creation number is vague. Usually 3 employees is sufficient. With EB-5, it's a set number of 10 employees. And we talked about buying a business as well. So let's run through an example. Okay, so in this example, Helen is, she's on an E2 visa in US, and she was on this visa in 2015, and she purchased the business for $300,000. So gave the seller $300,000. And the business had, some employees, and then she paid $40,000 in legal fees. Then at the end of 2019, she took another $500,000 that was given to her as a gift. And then, it describes where that money came from in terms of inheritance, et cetera. And also instead of the money, being given directly to Helen, the person who gave the gift deposited the money directly into Helen's bank account. Perfect. Okay, so yeah, so you just want to clarify there. Instead of giving it to Helen, the person deposited into the business bank account, right? When the money was invested, the new money, the 500,000, there are 10 full-time employees already there. She'd hired like 5, she had 5 and she hired another 5. And at the end of 2019, she also paid herself a bonus of $100,000. And, the company made $1 million. So she thought, let me give myself a bonus, and, it's my company, why not? And she applied for the green card, and she said, well, I've invested $1.8 million to 300,000 plus the 500 plus the 1 million in retained earnings. So, give me my green card, and I don't want to hire anybody else because I already have 10 employees. And her business is located in an area where the unemployment rate was 7%. So let's talk about some of the issues that come out of this example. So the first issue is that if you buy a business, the 300,000 that she spent on the business, that doesn't count for EB-5. That's completely fine for E2, but doesn't count for EB-5. The second issue is the $40,000 in legal fees. That can count for the investment in E2, but not for the investment in EB-5. And for EB-5, you have to show where that money came from in addition to the 800,000. The next issue that comes up is the inheritance. So the US government doesn't care, that the money came from, someone who died many years ago. They still want audit trail of where the money came from. And the other big issue is that the person who gave the gift to Helen didn't give it directly to Helen, didn't put it in her bank account, put the money in the business bank account. And that's a huge issue for EB-5. EB-5 says that the person has to be in possession and control of the funds, and they have to be the one investing. So E2 doesn't have that kind of strict requirement, but EB-5 definitely does. So that's another big issue. The next big issue is that she invested the money, when the company had 10 full-time employees. So the employees that were there before the money was invested don't count towards the 10 employees that she has to create. So now the other big issue in the next bullet point is she paid herself $100,000. So if you invest money, so let's say right now we're up to her investment being 500,000, right? So let's say she was closer to the 800,000 or something like that. If you invest money, but then pay yourself salary or bonus, that could be problematic because the government will say that you haven't actually invested the 800,000 or the max, the amount that you need to. So you have to, any distributions, you have to take that into account when you're looking at whether the person has invested the total amount of money. And then, of course, as we said, the $1 million of retained earnings doesn't count. And, it's nice that she doesn't want to hire any more employees, but she definitely is going to have to. So, yeah, so timing considerations with EB-5, the I-526 petition takes years, sometimes 4 years to be, adjudicated, and then you have to add in more time if the particular person, if the person is from a particular country, like sometimes China, for example, and sometimes other countries have been delayed, what we call retrogress, because only so many visas get issued to each country. So something to consider, like if you're in the US on a particular visa, you have to really plan everything out so that you maintain your visa status as you're waiting for the EB-5. And kind of monitoring when you're able to travel, when you're not. Definitely a great advantage having the I-485 being filed concurrently, because that gives people many, many more options. Some visas are what are called dual intent. So those ones are kind of better in the sense of when you do start a green card process. A lot of our clients do what we call parallel green card strategies. So they might do EB-5, but then also do NIW. It's completely fine, or have a family-based petition that's pending. Completely fine. And I think the key here is, planning is really key. And that's something that, you want to make sure that you are, looking at everything, so that you are making the best decisions and really kind of understanding what it is that you are doing, because given it is such a long and drawn out process, like, we're looking at we have many petitions where we actually end up suing the US government because they have taken so long to process the petition. We call them mandamus petitions. So we sue the US government and we compel them to act, say that 2 years is a ridiculous, but sometimes taking 4 years, but some clients don't want to sue because it's not free and it can be quite expensive. So, but some clients say, well, yeah, I want my petition adjudicated faster. So we sue the US government, and invariably, when you do that, they will, in most cases, not in all, but in most cases, they will just, instead of fighting the lawsuit, they'll just actually adjudicate the petition, right? So that speeds things up a bit. Perfect. Well, that is all I have today. And I'm just looking at the question box in the chat box. I don't see any questions here. So we will wrap it up here. And as I said, that we will send a copy of this presentation. We will send a copy of the actual webinar, and we will send a guide to you and also a link to set up a consultation if you have any questions. And again, I encourage you to sign up to for our YouTube channel and hit the notification button, as we do have regular webinars scheduled. Thank you very much again.